not been overturned. It has been modified. This court stated that substantial deference should be given to the goals and the judgment of the state in prescribing laws based on its local situation. Ewing further states that if there is a proportionality guarantee, it is narrow in the sense that it only prohibits those punishments that are grossly disproportionate to the crime. When we look to the reasoning in Solomon...
Doesn't the fact that this involves a 15-year-old kid kind of throw the whole thing and kill her, though? The idea of a juvenile is a special instance, isn't it?
Respectfully, no, Your Honor. This court only made that determination when the juvenile faces the death penalty in Roper v. Simmons.
Well, they said that when the juvenile faces the ultimate penalty, that you have to take into consideration such things as emotional development and things like that. It isn't life without parole an ultimate sentence?
Yes, Your Honor. Because of the decision in Roper v. Simmons, life without parole is now the maximum penalty. But Justice Kennedy stated in Roper v. Simmons that the state may not extinguish the life of a juvenile or his potential to understand his own humanity, but may exact forfeiture of his most basic liberties.
But the whole purpose of analyzing the juvenile differently is because that he has or she has the ability to be rehabilitated to a greater extent than an adult. Isn't that correct?
Yes, Your Honor. That was
rehabilitation within a life without parole sentence is kind of pointless.
Yes, Your Honor. That is the reasoning of the court. However, it is our position that rehabilitation is not just merely based upon the fact of being released, but it's that the juvenile or any particular offender may be able to understand the wrong and the error of their ways. And we contend that Mr. Denoff still has that opportunity. An offender serving life...
He's supposed to get a sense of satisfaction and when he lives 70 years in the penitentiary?
Well, not necessarily satisfaction, Your Honor. Rehabilitation just simply means that they're able to change their ways and not proceed into this criminal behavior or even the minor.
But what societal good does that get us? What societal good does that serve? Well, you're saying that they can be rehabilitated in prison and stay there, and they'll get the satisfaction of knowing they've changed. But what societal good does that do?
Your Honor, the key factor here is the goal of the state to separate those criminals, those horrific criminals, from public society. And the good in that is to keep people like Mr. Denoff off the streets from committing this crime again. When we look to the decision in Solomon, the reasoning there tells us that in order for a prison sentence to contravene the Eighth Amendment, it must involve a shockingly lengthy sentence imposed for a relatively minor misconduct. In our particular case, no inference of gross disproportionality exists for the violent crime of aggravated rape. Therefore, this court is not required to make inter- or intra-jurisdictional comparisons. As both Justice Scalia stated in Harmelin and Justice Kennedy stated, that these objective factors are irrelevant absent an initial inference of gross disproportionality. When we look to the logic in Harmelin, we must conclude that Mr. Denoff's sentence is not comparable to that of the capital punishment, because this court has always stated and always acknowledged that the penalty of death differs from all other forms of criminal punishment.
Well, you say that it's not the same as death, and of course it isn't, but it's still the maximum possible for someone of Denoff's age. Is that not correct?
Yes, Your Honor.
And I believe what concerns this court is whether the sentence would violate the so-called evolving standard of decency that we see in this country from over the years of our history.
Yes, Your Honor.
And we've seen it in the last few decades. And I think what we are concerned about is whether the Eighth Amendment could be violated in this sentence because it does violate that evolving standard of decency standard that now we know more than we've ever known before about young people and about the development of their minds and their characters. And of course the court below took that position as well. So could you give us a reason why we should just absolutely reverse?
Your Honor, the evolving standard of decency that I believe you're referring to is what this court acknowledged in Roper. Again, that is the death penalty. However, in our particular record, we see that there are only 10 states that do not have a minimum age of the imposition of this particular punishment. However, the record states that it varies throughout the other states. So we cannot infer that there's not an evolving standard of decency where this particular punishment is acceptable to society.
Counsel, you would concede, however, that young people are looked upon in a different way today than perhaps 50 or 75 years ago, and that we understand a lot more about the psychology and the physiology of young people. Isn't that true?
Yes, Your Honor.
And so if we do understand more about the developing brain of a young person, shouldn't we take it into account when deciding what turns out to be the most severe form of punishment, short of death, for a young person?
Respectfully, no, Your Honor. We must acknowledge the state's capacity to determine when enough culpability exists to even try Mr. Denal as an adult. Clearly, there must be some discretion given to the state. For instance, respondent may claim that this particular punishment could be imposed on a 12-year-old, a 7-year-old, an 8-year-old. Your Honor, we contend that that is not the actions of a state in their criminal justice system.
I understand that, but in order to defer to the discretion of the state, we have to have some sense, or a standard at least, when we can finally say the state has gone too far. And isn't what Chief Judge Wright referring to, this notion that as we understand more about people, we can then understand more about the appropriate and proportionate punishments. What concerns this court, I believe, is that this is the ultimate punishment short of death. And you're asking us to essentially say to the states, whatever you guys think is okay is fine with us.
Your Honor, just basically, it's our position that when dealing with a non-capital case, we should stick with this court's jurisprudence that death is different. And since Mr. Denal cannot be punished by the death penalty, we ask the court to leave all lengths of sentence within the hands of the legislature. We do not dispute that generally minors are treated differently than adults. But the key question here is who determines the minimum age cutoff versus the individual assessments. And we believe, or we contend, that this is a question of policy and should be left to the Olympus legislature.